Well, good afternoon, Michiganders. It is Tuesday, February 7th, and of course, this is Tuesday with Tom, Michigan's only weekly podcast where we answer your questions. Sorry, forgot where I was there for a second, where we answer your questions about estate planning and estate settlement in Michigan. As always, I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Last week's episode. If you own a manufactured home in a mobile home park, and you're looking for how can you transfer ownership of that manufactured home at your death without having to go through probate, that is what last week's episode was all about. So if that applies to you or someone that you know, I invite you or to recommend that they listen to last week's episode. Today's show, naming your sister as the beneficiary on life insurance to avoid needing a conservator for a minor child. That's kind of a mouthful, but we're going to talk about naming your sister or a brother or somebody else as the beneficiary on life insurance to avoid needing a conservator for a minor child. But please remember, what I'm about to discuss during the program, as always, is for educational purposes. It is not intended to be legal advice for you. You need to work with your attorney to determine what is appropriate for you and your estate plan. So let's get right to today's topic. I could rephrase it a different way, but here's what happens. You have a minor child and you want to provide them perhaps as a beneficiary on a life insurance policy, or maybe you want them to receive a bank account at your death or some sort of an IRA or investment accounts or some sort of asset that you're wanting them to receive at the time of your death. But what you know is that until they are 18, what would normally have to be done is that the probate court will have to appoint a conservator. That would be somebody that the probate court appoints who will receive that asset, be it the life insurance proceeds or the bank account, or the other assets that you're looking at, and they will hold on to those assets for the minor child until they get to be 18. But your concern is to have a conservator appointed. Now your estate has to go through probate. And that is something that you want to avoid. So when you looked at your estate plan, you've said, I don't want my estate to go through probate, yet I want assets to be available for my minor child. And what many clients are going to do at that point in time is they'll say, hey, I have a sister. I'll simply name my sister as the beneficiary on the life insurance policy or the account. Doesn't have to be a sister, can be anybody, but I'm going to name this person as the beneficiary. They will then receive the proceeds, and then they will in turn use those proceeds for the benefit of my minor child. So that's what you do. To avoid probate, you look at and you have the beneficiary change form done on your life insurance policy, or you look at the TOD and the POD and your bank accounts, and you have those accounts go to that individual. But before you do that, and if you have already done that, my advice to you is don't name your sister or your brother or somebody else as the beneficiary, because here's what you need to think about. Let's say you do that and you die, and just make life insurance, make it easy. So you've named this person as the beneficiary on your life insurance policy. You die. They file the application with the insurance company. They get the proceeds. Now what? Ask yourself, first question, who owns, in that case, the proceeds from the life insurance policy? Your child or the person that you named as the beneficiary on the policy? And the answer is going to be, it is owned by, or those proceeds are now owned by the person who you named as the beneficiary on that life insurance policy. Next question. Does that person who received those benefits on that life insurance policy have any obligation whatsoever to use those proceeds for the benefit of your child? Let's say you've even gone and you did a will. And in that will, you've indicated that you want your estate to be used to take care of your minor child. Let's say in that will, you even say, Susie, who happens to be my sister that I'm going to leave these proceeds to on the life insurance policy, I want Susie to take care of my minor child. That does not create any legal obligation on Susie's part to use those life insurance proceeds that you paid to her. Susie's obligation to manage an estate for your child are only going to be those assets that go to your child, not those things that go to Susie. So, no, Susie doesn't have any legal obligation to use those proceeds to take care of your child. And what if she chooses not to? Maybe you talked to her about it, said, hey, Susie, I'm going to make you the beneficiary on the life insurance. You just use those proceeds to take care of my daughter so that we don't have to worry about having probate and a conservator involved. And Susie might even say, great, I'll do that. But what if she doesn't? If she doesn't, there's nothing that you can do. There's nothing that anybody can do to force Susie to now have to use those proceeds to take care of your child. So you're counting on Susie carrying out your wishes, but she doesn't have to. But obviously, we have to make Susie the good sister. If she wasn't, you wouldn't be naming her. So Susie's every intention is, I'm going to use the proceeds from this life insurance. So I'm going to take that maybe a couple, few $100,000, million, whatever the proceeds happen to be. I'm going to put them in the bank, and I am going to use those proceeds to take care of your daughter, just like you asked me to. When Susie now uses her money, it's no longer yours, it's not owned by your daughter, but when Susie uses her money to take care of your child, essentially every dime that she spends is a gift. It's a gift from her to your child. And if during the course of the year, Susie spends more than in 2023, $17,000 from this life insurance, or total from all assets for the benefit of your child, now Susie has to concern herself with potential gift taxes. And the gift tax rate is 40%. No one wants to pay a 40% tax. So what you're setting Susie up for is a potential gift tax issue that she now needs to address. And she needs to account for that when she files her income tax returns. So Susie has to be mindful of that when she does exactly what you wanted her to do. When there could be other ways to handle it, where the money would be available for your child, yet Susie would not be making gifts to your child. And the last consideration is this: what if, and you have to look at this, what if Susie dies? What if she dies before ultimately all the proceeds are given to your child? Now what? Well, those proceeds of your life insurance policy that were given to Susie are now part of Susie's estate. And they will go with Susie's estate plan. And if Susie, like 80% of the people out there, hasn't put an estate plan together, the state of Michigan will determine where those life insurance proceeds are going to go to. In all likelihood, that is not going to be your daughter. If Susie's married, look at her spouse. If Susie has her own children, look at her children. So in all probability, if Susie dies before all of those proceeds are distributed to your daughter, those proceeds are going to go to somebody else who even has less interest than maybe Susie had in using those proceeds to take care of your child. So, should you name, in that case, Susie as the beneficiary on your life insurance policy so that you can avoid the need to have a conservator appointed for your minor child? Answer no, because there are alternatives available. Even if it had to go through probate, even if that were to happen, at least there's a probate court involved and the proceeds belong to your daughter. And we don't have to worry about if Susie dies or if Susie doesn't do her job, there's a probate court involved that can enforce the terms of the conservatorship. But if you want to avoid probate and you still want those proceeds to be available to take care of your child, that's where you will start considering a revocable living trust. The revocable living trust will receive those proceeds, not Susie. Susie might be the trustee, but Susie doesn't own what's in your trust. She merely has to manage what's in your trust and use it as you have so designated. So if rather than making Susie the beneficiary on that life insurance policy, you had a revocable trust, you put the life insurance proceeds into that revocable trust, even if Susie is a trustee of the trust, her obligation legally now, if it's set forth in the trust, is to take care of your daughter or your child using those proceeds. They are not Susie's proceeds. It is not a gift every time she spends money on your child. And if Susie dies, now your successor trustee is going to step in and continuing manage those benefits for your child. So if you've already done where you've already put your sister Susie on those things, you need to revisit that today. You need to get that taken care of. If you're considered doing it, look at what the alternatives are that I'm sure you're going to agree are better alternatives where you now don't have to worry about Susie. And I'm going to give you one other thing to worry about. Susie gets your life insurance proceeds. Susie has an automobile accident and kills somebody and gets sued. What does Susie own that might be subject to her creditors? Or Susie goes bankrupt, or Susie gets divorced. All these things that can happen in Susie's world that you have no control over. Your life insurance is at risk. It's at risk for Susie not doing what you want her to do. It's at risk for Susie's creditors now. It's at risk for Susie's heirs if she dies in the meantime. So if you looked at that and you really want the proceeds to be there, to be sure the proceeds are going to be there for your minor child, then don't name your sister as the beneficiary. Well, that's going to be it for today's topic. Kind of a brief topic today, but as always, Amanda and I would be honored to have the opportunity to help you protect your loved ones by putting together your own estate plan or perhaps amending an estate plan that you already have. Simply head on over to Doyle Law PC, our website. There you're going to find information on how you can schedule a consultation. It might be a Zoom call, telephone call, in-person consultations, but you'll be able to arrange all of that through the website. So simply go to doylelawpc.com and you'll be able to schedule your consultation with us. If you only need an individual document, maybe you already know all I need is a new healthcare power of attorney, then I invite you at our website to visit the legal store where you can order, you can't download, but you can order individual documents that we will prepare and have delivered to you. As always, if you have a comment about the program or a topic that you'd like to have me discuss, questions that you'd like to have me answered, please send me an email, tom@tuesdaywithtom.com. Follow us on Facebook, follow the office on Facebook. That would be Tuesday with Tom, as well as Doyle Law PC, and invite your friends and families to do as well. Remember too, that This podcast is available probably anywhere that you normally listen to podcasts: Apple Podcasts, Spotify, Google Podcasts, iHeartRadio, Spreaker, all these different services that are out there. You'll likely find Tuesday with Tom available. And if you have a smart speaker, you can always ask your smart speaker to play Tuesday with Tom as well. Well, thank you for spending some of your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.